Thank you. We're going to start up with panel 2. Thanks, everybody. All right, so I'm Professor Baer, and it's my pleasure and honor to introduce both our speakers and our commenters. Starting with to my right, we have Jennifer Pacella from CUNY Baruch. Then we have Anig Dambalajian from Tulane. They're going to both do their projects, and they'll talk to us about their papers. And then our commenters are Christina Skinner, who will soon be joining us here at Brooklyn Law School, and Rebecca Scheinberg from the Carlisle Group. And after they've had a chance to comment, I'm going to throw out to the group, see if they have questions for each other, and then if we do have time, hopefully we can ask audience members if they have any questions. So with that, Jennifer, take it away.
Okay, hi everyone, and thanks Jim for organizing today and the members of Brooklyn Law School for this great conference on this very timely and important topic. What I'm going to be talking about has to do with what really I view as the negative flip side of reliance on technology in compliance, and that would be cybersecurity concerns. Now I look at this really in light of the increased regulatory attention to this matter that's been given specifically by the Securities and Exchange Commission, which really has asserted itself as sort of a key regulator in cybersecurity. Another area of recent SEC focus has to do with whistleblower protections. So I incorporate that here, try to make this connection, and think about the role of whistleblowers in conjunction with really building the type of corporate culture of compliance that's necessary to address cybersecurity issues. So as I mentioned, I view this as the negative flip side of reliance of technology in compliance. It seems that every day brings more news of another data breach, another cyber threat, cyber crime, susceptibility to hacking and things like that, which really is a direct result of the increased focus in reliance on technology in automated compliance and control systems, using technology to monitor transactions and testing systems, also the ubiquitous electronic storage of data, and just the fact that we're overall living in a financial age. There's also an internal risk, too, to contractors and employees who may have authorized access to systems but might be interested in exploiting those or misappropriating information as well. All of these concerns bring about a general concern for cybersecurity. Now, the costs associated for any type of financial institution and business in cybersecurity are really so vast that they're even hard to put a number on and to quantify. In fact, many of the costs associated here do go unattributed or unreported. Entities oftentimes find themselves also hesitant to fully disclose information because of fear of liability or opening themselves up to kind of a roadmap of future hacking. But some of the most common costs that are associated with cybersecurity usually include an increased response from the executive team and the IT response. There's often a need to purchase insurance to sort of mitigate risks here or appease customers. We often see a decrease in stock value in entities, stolen intellectual property, litigation, goodwill and reputational costs. All of these things build up to put the massive dollar amount on what we see as a very expensive problem to manage today. Now, cybersecurity really lately has been deemed to be a compliance issue because many of the sort of known cyber attacks that have occurred are thought to have been able to be avoided through adequate and internal controls. Now, traditionally, the response to cybersecurity was left to the IT department, but today, because of the increased focus of regulators, compliance officers and compliance departments really need to be much more involved and concerned about this, especially because, for example, the SEC has even threatened enforcement action against compliance professionals for any failures or sort of misconduct, specifically in cybersecurity. This also has an ongoing effect on the legal and business aspects of any entity, so it should be one of concern to the board of directors as well. It's commonly viewed as an operational risk issue, so it is one where, say, the risk management and compliance department if they're not already connected or maybe housed in one department, would want to be sort of collaborating more on this and communicating more with each other, along with the IT department as well. So as I mentioned, regulators really have ramped up their efforts in addressing cybersecurity. That includes a number of different agencies. Just to name a couple, we've got the Federal Trade Commission, the Commodity Futures Trading Commission, and even on the state level, the New York State Department of Financial Services. All of these entities have spoken about the issue or come up with regulations. What we have now is a patchwork of law in cybersecurity that's really governed by individual regulators depending on the industry, so there's not really one federal law to govern here. And I specifically focus and kind of turn to the focus of the SEC on cybersecurity. Now, the agency has promulgated binding cybersecurity regulations on certain types of entities. So they've done that for CSI entities like self-regulatory organizations such as FINRA, clearing agencies, plan processors, to really make sure that they have safeguards to ensure personal information is secure and other security measures. There are also regs imposed upon, of course, financial institutions and creditors to protect against things like identity theft. For all the rest of sort of the entities out there, for the regular registrant who has regular reporting obligations with the SEC, what we have is a guidance issued by the SEC in 2011 specifically on cybersecurity. And what it does is it alerts all of those who have regular reporting duties to the SEC to disclose all of the information that they feel would be material in terms of the risks that they're facing in cybersecurity. Because at least from the SEC standpoint, they really think this is of concern to investors and comes down to a materiality question. So we have this guidance. It's very short. It was issued, in 2011. And it lacks the force, though, of a binding SEC regulation. In fact, there's just an explicit disclaimer across the top stating that this is neither a rule nor a reg of the SEC. At the same time, it calls upon entities to make sure they're disclosing risks in this arena. It's been criticized in the past for being pretty vague, very general, with no dollar thresholds. At the same time, the SEC, though, discourages the use of sort of boilerplate or generic risk language. And because it's only merely advisory tool, the SEC, though, has relied on it in a way to also kind of threaten enforcement actions against companies for noncompliance by circulating comment letters and sort of being more proactive in having entities police their cybersecurity risks. So the other area that I mentioned, and this will just be kind of a side to make way for the rest of the discussion here, SEC, as I mentioned, is also very concerned about whistleblowers and their role in compliance in general. And whistleblowers do play a key role in compliance, and what I'm specifically referring to here are internal whistleblowers who report information within the four walls of their organizations. So they're reporting it sort of up the ladder, ultimately to compliance officers or to the board, rather than going externally to the government or to the media. This is very beneficial to any compliance system because it would promote the use of internal reporting channels to raise issues that then need to be addressed by management. Many organizational benefits emerge from this, including avoiding any negative press, avoiding publicity and litigation, and it's really about capturing red flags, of course, in this arena too, that may otherwise go unnoticed. So many, and they also help to improve, corporate culture if you're in an entity that's really one that is empowered to be listening to whistleblowers. So many of the benefits that whistleblowers bring about in compliance are actually the same methods that administrative agencies had said are best to manage cybersecurity practices and risks. And those include really an increased response from compliance officers, a proactive role of the board. It's important to have internal reporting systems that actually function and work, and assessments on the area. Also important here is the implementation of a clear employee guide to so that employees know that they can be empowered to detect, prevent, and respond to any cybersecurity threats across the board. In fact, for example, the SEC has stated this is not one person's job, it's really a multi-stakeholder effort that they said starts at the keyboard, right? So in terms of raising with every single employee, whatever it is that they're noticing may be going wrong here, they should be empowered to report on this. So I really hone in on sort of what I call cybersecurity whistleblowers who are reporting on information in the cybersecurity arena. And that can be very, very broad. It could include things like reporting on, others sharing passwords, who's sitting across the hall from you. Maybe you have authorized access to your computer, but others are allowing friends or neighbors to sign on as well. This really focuses on the human factor of cybersecurity and brings to mind the importance of keeping networks safe. In fact, very recently, a prominent law firm held a webinar on the topic, actually calling cybersecurity whistleblowing the next wave of SEC whistleblowing. So we see that others are kind of thinking about it. It has emerged in regulated entities. Now, the problem that we have here is that just like a traditional whistleblower who is often retaliated against, this is still the most common response to a whistleblower, cybersecurity whistleblowers who escalate concerns to compliance officers and to the board risk retaliation as well, especially in entities that have manifested a corporate culture of silence. In fact, in my opinion too, the risk of retaliation in this arena may be even stronger because we're dealing with an area that is very difficult, very costly to address. It may certainly be one that managers don't really want to hear problems about. And as it's been noticed too, the typical constituents, say a typical board of directors or even compliance officers, probably unlikely to be very well versed in IT issues and handling cybersecurity concerns that sort of emerge from their ubiquitous reliance on technology. So it may be an area that they don't feel comfortable in addressing. The risk here is that if you've got a whistleblower who's ignored or is facing retaliation, they may be prompted to go straight to the administrative agency, specifically for the SEC. They may even be more prompted to do so in light of the fact that Dodd-Frank offers bounty rewards or cash incentives to whistleblowers to bring forth information. Now, just in looking at sort of cases of entities that have had cybersecurity problems across the board, I have found several examples already occurring of cybersecurity whistleblowing that have been spanned across several different industries, including, of course, financial institutions. And those could be as simple as one example involved a company password policy, for example, that was too weak, that was allowing access even after deliberate typos that were raised. And the whistleblower noted this to senior management for 2 years, actually, and was told to stop complaining. And it was, a problem that then built into something greater. There's also been cases of people reporting on the improper storage of client information electronically, unauthorized access and use of data information, sharing of passwords. The potential here is really broad because these problems, you're kind of operating on a technological system. They may be hard to pick up if you don't have sort of the human factor, the human element of noting some of these things as problems. Now, then we turn to the protection of cybersecurity whistleblowers here. If this is going to be an area of importance to financial institutions and companies, it would be essential to also protect such persons, especially those reporting internally, so that they do feel empowered to kind of help the entity respond and detect the problem and then have it be managed. Now, when it comes to the federal securities laws, we have a couple different statutes that offer whistleblower retaliation programs. And one is the Sarbanes-Oxley Act, the other is the Dodd-Frank Act. Both of those offer remedies to whistleblowers, with Dodd-Frank being the more robust of the two, and whistleblowers get better remedies through that as well. But to seek relief under the statute as a whistleblower, you would have to have reported on a reasonably believed violation of a law, rule, or regulation under or subject to the SEC's jurisdiction. Now, what I'm viewing is just kind of a red flag, a problem emerging, in which this recent webinar also echoed too, is that any sort of perceived violations of the 2011 guidance here would not be likely to fall under what constitutes protected activity, given that that guidance is non-binding, right? It's the guidance that I mentioned that's out there now for registrants that lacks the binding force of law. So if you're a cybersecurity whistleblower kind of raising a concern, maybe we didn't make an adequate disclosure in this arena. We could be doing better on this. And you are retaliated against, may end up with a problem in terms of claiming that you fit the threshold of the statute here for what constitutes protected activity. And just in looking at case law that mostly comes under Dodd-Frank, this seems to be the case. Many whistleblowers have trouble getting past the motion to dismiss stage, especially because many have not been found to have reported on an explicit violation of the federal securities laws. That's been interpreted really narrowly, especially with indications or laws that don't impose a clear duty to disclose. And with the guidance, it's really more of a question of the regulated entity to determine whether the question is one of materiality or not that would merit disclosure. So it's something reporting entities have to think about, but it hasn't not yet been imposed as sort of a binding obligation that they face. And just a final thought here has to do with, another concern that may emerge with cybersecurity whistleblowers has to do with whistleblower bounty programs. And as I mentioned before, those are cash reward programs that are intended to incentivize whistleblowers to come forward. The idea is that this would offset all of the typical retaliation that they face. Several statutes offer these programs. Dodd-Frank does in terms of federal securities laws violations, as does the False Claims Act for any instances of fraud against the government, and so does the Internal Revenue Code for tax noncompliance issues. But to get a bounty under the statute, you'd have to report on what's defined as original information. That is commonly defined as information not already in the public domain, that is derived from independent knowledge or analysis. Now, the problem here, and this is a separate question from retaliation, a cybersecurity whistleblower for an entity who is not traditionally seeing or hearing a problem of wrongdoing may be more likely to report over problems observed over technological systems, over maybe even the internet, or to some other system to which others may have access, and thus might not be able to prove that the information they're providing is original. So they may find themselves precluded from these bounty rewards as well, which really has been a huge way that regulators have gotten very good information in their pockets to bring forth enforcement actions, because otherwise they're really having a hard time detecting enough information. So it really is also a compliance tool. And one commentator has noted this already, saying that companies can defend themselves possibly against whistleblower claims by sort of exhaustively searching the internet, searching their technology to prove that the whistleblower, wasn't exactly the first to kind of bring this up, that others may have tremendous access to it. So just in conclusion here, I think it's a growing area of interest, and one in where the human factor of technology kind of plays in, and that whistleblowers have the potential to be raising red flags here to help try to manage the problem. Okay, so I'll end there, and I look forward to questions later. Thank you.
Okay, I didn't do a PowerPoint. I figured since I get to present in technically the second half of the program, a lot of what I would probably talk about has already been covered, and it'll probably be a little more interactive in that sense. So I get to check my outline and just shoot from the hip a little. First I wanted to thank Jim and Roberta and the students at Brooklyn for hosting this. I think this is a great topic. I've been trying to write a bit more about information technology and how it affects capital markets in recent years, and I think this is a very good topic because it does pose this basic question that's fundamental not just to what lawyers do, but also to what traders do. Are we eventually going to beat the machines, or are we going to, succumb to computerization? This is as true for the traders, I suppose, as true for the financial advisors. You've all read about, robo-advice, as it is for lawyers, doctors, and professionals across the board. In some sense, you might even say that financial services is one of those areas where, we really should be automating more. After all, it's largely a quantitative exercise. Trading, it can be done perhaps more efficiently by algorithms than by human beings, at least if you're talking about routine types of transaction. And frankly, helping somebody plan for retirement advice or plan for, major life events is, while it involves an element of hand-holding, is also largely a quantitatively driven exercise. So this is an area where, technology does have a role to play, but it does pose, issues, not necessarily problems. By way of background, I studied computer science because I get along with computers better than with people. So I'm going to take the, I guess I'm not supposed to declare, right, pro-technology. I think technology is inevitable, as some of the commentators on the prior panel said. I think it's a good thing. I think it's being driven by regulators. And so what I thought I'd do is structure my talk around the following 3 points. One, why have regulators embraced technology? And the reason I think they've embraced technology is partly because the recent crises, both in terms of systemic risk, both in terms of operation and in terms of operational capability, have required the agencies to provide some sort of real-time monitoring of markets. Plus, I also think that just, I don't want to say the failure, but the inability of the SEC to maintain its traditional posture of regulation by enforcement has required it to think a bit more creatively about how you supervise firms, how you monitor firms on an ongoing basis. Rather than detecting fraud after the fact and bringing a suit, what we really should be doing is monitoring markets continuously. So, issue number one, why have regulators embraced technology? Issue number two, how do we deal with the inadequacies of technology? I think this is where the threat element comes in. Several of the panelists on the prior panel talked about the fact that you need that human element in there somehow to counter the limitations of technology. You've all read about this. I'm not going to repeat a lot of what you've read in the general sense, but I would like to talk about some of the specific areas in which human intelligence needs to counterbalance technology in financial services, particularly from a compliance standpoint. And I think some of those areas are information management, in the sense of trying to figure out the right balance between what regulators pull and what firms maintain, and how firm compliance personnel deal with the competing demands of their superiors, their traders, and the regulators. I think there's also the question of homogeneity in regulation, the risk that firms will sort of through inertia fail to update systems, or because they're relying on the computers to find the problems. And I think there's also just the general anxiety that nobody really knows what's going on, as I think David mentioned or John mentioned on the prior panel. To the extent that we've turned trading over to computers, how are compliance people supposed to stay ahead of that? The third general theme of the talk is, mostly I guess directed at the students, because the rest of us probably have jobs. How do you find jobs in compliance? Now, I'm ill-qualified to say that because I'm a law professor, right? But what I can tell you is I think the compliance officers of the future need to not only understand the rules, they also need to understand the business, and they also need to understand technology, which means maybe setting aside biases against the revolving door, thinking more generally about a career arc rather than that first job out of law school. You need to be more than somebody who detects and punishes. You need to be somebody who is an architecture and engineer of compliance, who understands how to add value, but perceptively, both for internal marketing purposes and for purposes of assuaging the regulators. And so I'll try to talk a bit about that. First of all, I'm not going to go through the litany of things that the regulators have done, but certainly when you talk about, what have regulators done, to embrace technology. A lot of the recent movement on the part of the SEC and FINRA is to develop some of these big data approaches to surveillance of markets. You have, on the one hand, automated information dissemination. Now, through these XBRL programs, firms will disseminate information, via the internet in coded form, which is much more easily digestible by algorithms. Regulation AB for asset-backed securities requires a lot more granularity in the type of information that's disclosed, through XBRL. And the idea is not only will regulators use it, but we expect firms to use it as well. So again, the regulators take the approach, if we build it, you will come, right? As the prior panel said, you have to use this information if it's publicly available to satisfy your compliance obligations. More importantly, the SEC has moved on to enhancing information retrieval. We've got the Consolidated Order Audit Trail system, which is, requires firms to maintain detailed records of their trading activity. Certainly in the derivatives side, we have the various swap reporting requirements and repository requirements, to be able to monitor on an ongoing basis certain types of derivative transactions. We have the new Office of Financial Research in the Treasury that's designed to build these tools for monitoring markets and also for extracting information from firms in standardized forms, a topic I'll come back to later. And then, the third iteration of this is the programs that everybody talked about on the prior panel. You have MIDAS, the Market Information Data Analytics System, which the SEC is going to use to monitor trading. You have the National Exam Analytics Tool for purposes of monitoring insider trading by firms and by monitoring client affiliations. You've got FINRA's Sonar system, again, FINRA's branded version of this sort of insider trading monitoring, anomalous trading monitoring, and then perhaps most interestingly, this new system called CARDS, a Comprehensive Automated Risk Data System, which will move beyond your traditional market tactics and focus perhaps more on issues like suitability. So imagine a computer supervising for compliance with suitability requirements, churning requirements, and so forth. So that's kind of a very nutshell picture of what the SEC is trying to do. Again, I think they're motivated by the need to deal with some of the things we've witnessed in the market, systemic risks, the recent crisis of 2008, the flash crashes and other catastrophic events. Beginning as early as Y2K. I know many of you don't remember that, but there was a time when dates began with a 19, right? And we all went through that Y2K hysteria for a few years, and the SEC adopted a lot of operational capability rules during that period. And also, nowadays, we worry about market liquidity as well. So we need real-time regulation in a certain sense. What's ironic about it, though, is that we build these systems that are ostensibly designed for systemic risk management, and we use them for the kinds of $10,000 trades or $20,000 trades that we discussed on the prior panel. Once the tool is there, how do you not use it, even for the more perhaps mundane, routine, small dollar, violations as well? I think part of the SEC's reason for this shift again. They need to start, governing by standards as opposed to governing by enforcement. Some of you in the academic community have probably seen some of the recent studies criticizing the SEC's, enforcement statistics and how they try to, beef up their, their reported actions because of the difficulty of bringing, litigating, and racking up statistics. On that end, I think that's going to signal, again, a shift to prophylaxis as opposed to ex post enforcement. And also, just the fact that there are so many rules, right? And so many complex rules. You've got AML, you've got privacy, foreign asset control, identity theft. All of these things are hitting compliance officers at once. You've got due diligence obligations, which mean that you have to pull publicly available data in order to comply with them. Best execution, now you have to pull information from multiple exchanges as opposed to perhaps, just a consolidated tape. Credit worthiness, we can't rely on S&P anymore, so we have to do our own credit analysis based on public data points. Communications with clients regarding complex products. We need not only to provide customers with term sheets, but also computer models of how transactions will work or how securities will perform. All of that requires a certain need, for technology in compliance. So where do the models fail? or where do the computers fail, and where do human beings need to step up? Information management is one of the areas I think is important here. Certainly, there's always a tension between just giving the regulators everything they want, or the regulators pulling everything they want, and firms curating information to provide on a regular basis to regulators. The difficulty with the latter is you need people who understand the information, who understand the regulators, and can respond to requests for information. So I think compliance officers, people who know the rules, people who curate information, need to be able to perform that function in order to act as a bridge between firms and regulators. A second area, obviously, is the homogenization of compliance practices. Certainly, we all want to believe that many of the standards that we talk about in class or that we talk about in the industry are qualitative. Things like fiduciary duty, things like materiality, and of course, regulators will periodically play with their algorithms in order to create the appearance, or maybe even the reality, that we are constantly rethinking how these concepts should apply. For many firms, particularly smaller firms, you're buying off-the-shelf software, presumably, to deal with these problems. For larger firms, presumably you'll have the in-house capability of building out systems, but those systems have to be rolled out on a regular basis. And, as the prior panel says, the compliance algorithms don't necessarily keep up with the trading algorithms, or often the need to introduce new compliance algorithms will trip up the ability of the business side to roll out new trading software. So again, there's this risk that you're going to wind up with outdated or homogeneous systems to monitor what we think of as qualitative standards. This means you need compliance officers who understand, the qualitative standard and can think actively, dynamically, on an ongoing basis what needs to be done to bring the algorithms in line. Just think of the best interest test. I mean, how do you program something, a fiduciary standard like a best interest test, when you're dealing with a firm that has conflicts of interest? It's almost impossible to think about how you would do it, and yet you need to do it in order to be able to monitor a firm effectively. There's also the general question of, obviously nobody knows what's going on. It's not just a question internally of compliance officers not necessarily keeping up with traders who don't necessarily keep up with algorithms. It's also a question of how do my systems interact with everybody else's systems. To the extent that I want to build an IT infrastructure that deals with, that is triggered by liquidity, or engages with the market or withdraws from the market based on information that I'm getting from everybody else, there is a risk that systems won't be interoperable, or worse, that they'll confound one another and create crises like the flash crash. Again, you might say this is an IT problem, it's not really a compliance problem, but it's the compliance officers who are the bridge with the regulators. When the regulators try to design such systems, when the regulators propose systems that may have unanticipated or unforeseeable effects for a firm and its trading system. So I think it is, to a certain degree, a compliance problem as well. At the end of the day, the compliance officers, face a certain degree of liability if, they know about these problems or have reason to know and can't deal with them effectively. I'm not going to speak too much about compliance culture. I think, we've talked about the impact of, a technologically driven compliance architecture on firm, particularly rank and file personnel. The only thing I will underscore, as I think several of the panelists said on the prior panel, the danger here is that compliance officers will silo themselves. And part of that is a result of, the SEC's, jurisprudence saying that, supervisors, or compliance officers who engage and either, could have influenced or perhaps even could have compelled traders or associated persons to act in a certain way will be on the hook if they fail to intervene. That creates perhaps a certain reluctance to engage too much. This is particularly a risk for, you might say, the larger firms. For smaller firms, the compliance officers are typically also the supervisors, are typically also senior business people. They wear multiple hats. They have to perform this role. With larger firms where you can have a segregation of functions, hire lawyers to do compliance, promote business people to act as supervisors, there is always a risk that those two groups will silo because the compliance officers may not wish to assume supervisory liability, or may be reluctant to engage to the extent that they might cross Commissioner Gallagher's line. So again, these are things to think about when designing a compliance architecture within a firm. So I know I've only got 5 minutes left, and I'm trying to cram my entire paper into this, which is probably not a great idea. But let's see if we can finish this up. What are my suggestions? Again, I think I'm more interested in what sort of the people out there have to say about this than what I have to say about this. But I'll throw it out, and maybe it'll start a conversation. Maybe it won't. I think your compliance officer of the future is, again, an architect. And not a mechanic, right? This is somebody who has to have good relationships with regulators, good relationships with the business people at the firm, and good relationships with their peers at other firms, because regulation of the future is going to be a collaborative standard-setting project, right? We're all forced to adopt IT. We're all forced to think about how to code some of these things into our systems. The regulators are imposing certain standards on us for regulatory record-keeping and reporting purposes. Those are going to influence how we implement our own compliance systems internally. And so if you can think of the compliance officer of the future as this person who acts as the mediator between regulators, business personnel, and as ambassador to peer firms, you might be able to add perceptible value to your firm as well. How would this work? I think the devil is always in the details. The first thing you need to do is automate what can be automated to relieve compliance officers of perhaps the more mundane burdens. One quick example: FINRA could probably buy a contract with one of these diligence firms to take over the entire U4, U5 supervision, the supervision of the record keeping for associated persons of brokerage firms. There are certain things that perhaps firms shouldn't necessarily bear responsibility for as a compliance matter when it can be more effectively centralized within a regulatory agency like FINRA, and that would create room for firms to perhaps use their subjective judgment a bit more to advance the qualitative standards or the qualitative just and equitable principles of trade. I think also, we need to sort of abandon prejudices against the revolving door. Certainly there's a lot of commentary about how bad it is for, firms to hire people out of industry and vice versa. Certainly when I, grew up as an associate at my law firm, I wasn't necessarily encouraged to leave and go join a regulator. But I think, part of what you do as you gain different experiences, whether it's on the trading floor, like Roberta was talking about, whether it's at the agency or whether it's in a law firm or whether it's in the compliance office of a brokerage firm, you do learn how all sides of the business operate. And I think to be effective in the future, to be able to understand technological systems, to be able to explain to traders why the rule is what it is or why your interpretation of the rule is what it is, you need to be able to speak that language. So I think part of the arc, perhaps, of the future compliance officer has to be a bit more circuitous, learning different types of skills to be able to act in that kind of, ambassadorial capacity. I think, there are also things that, regulators might try to do to enhance the internal perception of compliance. I'm frankly not terribly persuaded that any of these would work. Traditionally, we haven't thought of compliance, a good compliance record, as a positive. It's usually not a negative in enforcement proceedings. And so, I've been doing these hearings for FINRA, and people will come in and say, well, we have a clean record for 20 years. We've never done anything wrong. We screwed up this one time. And it's always, well, sorry, obviously if you have a bad record, we'll take that into account. But, your good record counts for nothing. It's conceivable, Mayor Bloomberg, adopted, your letter grades for restaurants. I don't know if we want FINRA adopting letter grades for brokerage firms, but they certainly do issue report cards that tell you how your firm is doing with respect to compliance. There may come a day when, FINRA or the SEC will provide, investors with, more detailed information about how their broker is performing. I tend to think that won't happen, A, because we'll never agree on the standards for performance metrics, and B, I think performance metrics just create a new set of obstacles to game as opposed to improving the quality of services. But I think if we can come up with ways to enhance sort of the value of compliance, or at least treat compliance as something more than a cost center, that will also help improve compliance culture down the road in a world of technology. So I think I've hit all the high points, and I look forward to the comments. Thank you.
Thank you. All right, so now we are on to our commenters. Christina.
Well, thanks to Jennifer and Onig for these really interesting presentations. I also enjoyed very much reading your papers, and so my remarks will mostly focus on the papers and how they fit in with your presentation. So with Jennifer's paper on cybersecurity compliance, she's studying the need to encourage what she's calling cybersecurity whistleblowers. So these are whistleblowers that are reporting internally, as she said, and flagging internally a company's vulnerability to certain cyber risks. I think the paper in particular makes a couple of really valuable contributions to this growing literature that we have on the regulatory design of whistleblower programs and the SEC program in particular. So first, I think it's really novel and quite thought-provoking of her to point out, as you carefully do, how there's this tension in the current regulatory framework, right? So there's significant value, she discusses, for managers, for shareholders, and for market stability more broadly in having whistleblowers in the firm point out cyber vulnerabilities. And yet, at the same time, it's likely that we're seeing these whistleblowers discouraged from doing so, given the lack of an SEC regulation that requires certain cyber-related disclosures. And so given this uncertainty that she points out surrounding the consequences of the whistleblower's actions, it's unclear at this point whether the law is really encouraging the socially optimal number of whistleblowers out there trying to ferret out and report on cyber weaknesses in a company. And so, the second contribution here, I think, flows from that analysis, which is her policy prescription. And, unlike a lot of academic proposals, it's really quite sensible, and as she carefully develops in the paper, within the realm of possibility. And so she's arguing that the SEC really needs to, under its authority, promulgate regulations requiring cybersecurity disclosures. So, following on from these contributions that she's making, I think that there are several really interesting areas for possible expansion in the piece that she's writing. And first, on this topic of whistleblower and compliance, I think that context is really important. So in some parts of the paper, you discussed or you suggest that whistleblowers can be perceived as really loyal actors, so trying to advance the best interests of the firm. But at other points, I think you quite rightly point out that whistleblowers are retaliated against and frequently perceived as troublemakers or snitches. And so I think there's a point here about the culture of reporting in the firm, which ties into your broader theme about encouraging a culture of compliance, which is that reactions to cyber whistleblowing probably vary between industries and probably within the financial services industry itself. And so once you sort of tweak this a little bit and flesh it out, I think you probably have some things to cash out in terms of how you would structure a policy proposal for encouraging cyber whistleblowers. The second thing I think you could consider is the unique posture of cybersecurity whistleblowers. So ordinarily, when we're talking about whistleblowers, we're thinking of someone who's reporting on some kind of misconduct, right? Some kind of misbehavior that has this normative weight of a morally bad or an unethical act, like fraud or market manipulation, misstatements, and misrepresentations. In contrast, I think the failings that you're talking about here could be more, and probably are more typically, operational lapses, so systems failures. And so it's not as clear to me that the conduct is this morally reprehensible behavior. And it might not even be clear to management at the time that its systems and operations are inadequate before this bad event, before a cyber intrusion takes place. So, why does this distinction matter? Well, I think when we're talking about unethical conduct or misbehavior, we can see why a company's management might be turning a blind eye. The behavior that's being reported on or whistleblown is probably somehow profit enhancing. But this isn't necessarily, I don't think, the case with cyber vulnerabilities, other than maybe the fact, as you mentioned, that you're saving some money, cutting corners on information security. In theory, at least, one would think that the costs to a firm of a cyber intrusion, in terms of cost to its reputation, the repair costs, legal inquiries, consumer redress, one would think that these costs are sufficiently compelling to incentivize managers to take the steps that they at least think are sufficient to protect themselves from cyber intrusion. And so I wondered about sort of how you're thinking about wrongdoing in this context. And then the third area, I think, for expansion in the paper is related. And it has to do with fleshing out the reasons why exactly companies would be motivated to retaliate against cybersecurity whistleblowers. So again, when we're talking about misconduct, like fraud, for example, or London whale type behavior, we can see why reporting on the misbehavior is probably going to expose or call into question some kind of business norm that's unethical or illegal. And the other employees in the firm and managers, they aren't going to like this because they want to continue doing things as before, and so they punish the whistleblower for rocking the boat, essentially. On the other hand, when you have a shoddy information system platform, it doesn't seem to be quite the same thing. So again, presumably it's costly with little upside to be vulnerable to cyber intrusions. So at least in the majority of firms, I think maybe discussing sort of what these incentives are for retaliating would be helpful in understanding how to shape the policy for encouraging whistleblowers to come forward. So moving on to Oneg's paper on preserving human agency in automated compliance, I think, again, very interesting and topical paper where you're making a quite novel claim that rather embracing automation wholesale as this productive compliance innovation, we should take a step back and think about the costs and the limitations of this automation. And so I think that the paper and the presentation really effectively draw attention to the fact that while we have this background assumption that automation and technology can be stabilizing forces, and you point out that automation and in compliance can accomplish a lot of things that human compliance can't, there are costs to shifting too far in this direction. So again, I think overall the main contribution here is questioning the proper role, the proper balance between human and automated compliance, and also framing this conversation in terms of costs and benefits and trade-offs. Because I think in doing this, you're sort of fitting this conversation into a larger one, which is one about the costs and the unintended consequences of some of the post-crisis regulation that we've seen unfold in the past couple of years. And so I think the paper is really making us think about whether perhaps we've discounted the extent to which automation can lead to complacence. So the absence of human judgment about risk, as others have mentioned earlier, the possible concentration of risk, increasing firms' vulnerability to certain kinds of risk, like cyber risk, in fact. And so as for more specific contributions of this topic, I think there are several. So one is this theme of culture that we heard in the earlier panel as well. And in talking about automation and a culture of compliance, I think one of the main costs, an important aspect of the discussion you have in striking the balance discussion, is drawing attention to something critical that automation can't do, and that's evaluating business norms and practices and evaluating the quality of the institution's culture. And again, as we've been talking about here, culture is really at the forefront of regulators' minds right now, and this should be, one would think, that placing a premium on culture and understanding culture is a reason to elevate the status and the resources that are dedicated to human compliance. The second interesting contribution and theme in the presentation and paper is this idea of complacency. So this paradox where automation can give us a false sense of security and risk management. I think the real irony here is that we've fallen into this type of complacence time and time again. And I think, some discussion in the paper of examples like long-term capital management and the fund's reliance on, hubris and complicated algorithms to think it was immune from risk and loss is sort of a historical lesson you think we would have learned, and even lessons from the crisis where there was a great deal of reliance on internal stress testing and modeling as a perceived buffer against serious loss. And then I think a third contribution here is, as I mentioned earlier, this discussion of a link between automation and concentration of risk. So I like this point that concentrating automation can make institutions more vulnerable, especially in the cyber arena. So sort of linking the two papers here. And so, I was thinking in particular about an analogy in the derivatives context where, by mandating clearing through central counterparties, some people are starting to question whether this concentration of risk in CCPs has actually exacerbated systemic risk. And then to the extent that you are looking to flesh things out as you develop the paper and keep thinking about this link between automation and compliance, I think first it would be interesting really to hear more about the institutional and the mechanical details about the measures that have been taken specifically. So you mentioned operational war games, things like circuit breakers and information stress testing, sort of explaining the mechanics of this and then evaluating how this falls on the spectrum of the cost-benefit analysis that you're doing. Second, I think there's definitely more grist for the mill in terms of the culture section and the culture theme that you remarked on, and particularly how regulators can improve, and you use this phrase, the perception of compliance. So, for example, we've been talking about this trend toward personal liability for compliance officers, and certainly that's something that DFS is really pushing right now, and just sort of exploring whether this push toward the personal liability of compliance officers is helping or hindering this effort to improve a perception of compliance. And then related, how can regulators, if at all, incentivize firms to effectively integrate the compliance function of the firm within the business units, which is something that you also touch on. And then lastly, I think there's a lot to be discussed in terms of intra-institutional dynamics. So in the paper, Onig mentions very briefly this link between peer institutions. And so I wondered whether there are ways or policies to sort of motivate or enhance compliance networking. Should compliance officers be talking to one another at various peer institutions, given the extent to which financial services is so interconnected in this way? And so to wrap up, I think what we've seen is that there are two sort of core cross-cutting themes in these two papers. The first is the need for more effective detection and prevention of various forms of risk, so market risk and operational risk, through alternatives to traditional command and control regulation and traditional compliance systems. And this is where technology can fit in, and striking the right balance is important. And then the second theme that we've seen in the two papers and in the previous panel as well is how to stimulate a culture of compliance, the importance of a culture of compliance, and making sure that technology serves and doesn't undermine that goal.
Great. Okay, and Rebecca.
Sure. So we've been talking a lot about technology. I think there have been a lot of really interesting points. But while technology is extremely important, it can't alone create a culture of compliance. So I'm going to talk a little bit about why I think the culture aspect is so important and where technology really comes into that. And for a lot of you who are students and looking for new jobs, I think that what I'll talk about are things that you should pay attention to, because as you go out on interviews, you feeling out the culture of where you could potentially be working is really important, because you want to make sure that you're working in a place where there is a strong culture, where they're not hiring you into an extremely senior role that you're not ready for, because they want to just put the liability on you. So that's just one thing to keep in mind. So one thing that I actually just wanted to cite for everyone here that I read in Onig's write-up that I found very interesting is, he writes, courts and regulators do little to dispel the perception of compliance personnel as a cost center. Then it goes on to say, beyond the sporadic enforcement action, however, there's little reason for firms to maintain more than a minimally adequate compliance structure because it is difficult and dangerous for regulators to assess compliance and to reward firms with a clean or outstanding compliance record. So I think that comment goes directly to a compliance culture. There's two ways to think about it. First of all, we can put the money in up front and we're gonna prevent those issues and it's gonna cost us less down the road. Or people can take that view of the statement that I just read and down the road, that's when it's gonna be expensive. That's when all your investors are gonna redeem their money and that's when you're gonna spend millions of dollars defending yourself against the SEC and other regulators. So just to open up. So what really is the role of a compliance department and a compliance professional? It's to develop and implement policies and procedures. It's to educate and advise the business. And it's to conduct surveillance and testing. So what does that mean as far as implementing the culture? There has to be a tone at the top. So we've talked about that before. And what does that really mean? It means having the right management people in place who take the business seriously and who understand that sitting on a trading floor and executing trades and making money for investors is not the only part of the business that they should buy into, that's important and that's going to help the business to grow and succeed. So if you have management who they sit on a trading floor, they don't care about what we tell our investors, how we market, that we may be subject to FINRA regulations in marketing, then it's a little bit of a telltale sign that you don't have the strongest controls in place. And when management at the top isn't on board with compliance, then somebody mentioned this earlier, that they cut corners and other people who roll up to those senior people feel that it's okay for them to cut corners. I've seen this before. I've seen great compliance programs. I've seen weak compliance programs. I've had the opportunity to work in consulting for a short period before I went in-house. And I saw a number of different clients, and large and small. And after working in-house, I spent 5 years, really the 5-year period that the industry changed between 2008 and 2012. I was at a large hedge fund. It was really when the SEC started looking heavily at insider trading. And it's something that they haven't stopped looking at. And if you're in a senior compliance role at any type of organization now and you haven't had a visit from a regulator, then I don't know, I'd like to meet you actually, because I don't know that there are any. So tone at the top and management is highly important. Training and education. So it's not just about developing policies. You have to let people know, well, here's what the policy is, here's what this means for you, and here's your job in complying with this policy. I actually think that a lot of the large institutions have really good and strong training programs. They bring in analysts at junior levels, and they have to work their way up. So the first day in the door, they're sitting and learning about compliance. And I haven't worked in a large institution, but I've worked with a number of people that come into my organization, and you can tell, based on their background, their views and their understanding of compliance and how they act from their first day in the door. I think that for all of you out here who are going to be out looking for jobs or are currently doing that, it's going to be a little bit different for you than I think it's been for me and some other people sitting at this table, where the industry has changed so much. And 25 years ago, compliance didn't really mean that much. It was a little bit more about checking the box, or so that's kind of how it was thought about. And now it's a real thing, and a lot of people that you're going to be working with on the business side, if you're in a compliance role, a lot of those people on the business side have grown up in this new type of culture where compliance is so important. So it's just something to keep in mind, that your peers probably have a strong sense of compliance, but certain people that may have more experience and a longer career track record than you do don't necessarily have that view of compliance culture. And it's not always easy to implement compliance policies and procedures with people who are more senior than you in a business and don't necessarily feel the same way that you do. So just a point to think about. So training and education, again, going back to that, how do we do training? There's multiple different ways to do training. What I personally like to do is sit in a room with people, eye to eye, like I'm looking at you. If you don't comply, you're gonna be sitting in front of me in a month from now, and you're not gonna want me doing that. So we'll be having a one-on-one conversation, and it's not gonna be a good conversation. So I like to be very practical about here's what the policy is, and here's what you have to do. And then, I actually get a lot of questions from people within the business that show that they're actually paying attention and thinking, and that's why I think having people sitting in a room is great. In a large organization, it's not always easy to do that, and a lot of times training is online and web-based, which also can be good because there's, again, back to technology, it's a way to reach out to people within the organization, and a lot of times what we'll do is there'll be test questions at the end that actually require thought, and they require you to understand the policies. And if you don't get the answer right, then it's going to be reported to compliance, and we keep logs of all of this. And you're going to have to go through the test all over again, and you're going to get new questions until you can answer it the right way. So with respect to cybersecurity, and I'm going to touch on cybersecurity a little bit more, but one type of testing is the practical aspect of it, of putting emails out there to the business that are phony phishing emails and seeing who responds to that. So I don't always pass these tests, right? I get the phishing emails, I open up the link, and I'm trying to be responsive to my emails. And then I found out, oh, you failed the test. So those are just all different ways, and I think it just goes to the point that technology is helpful to compliance in that type of a way. But another thing that's really important is budgeting. So one thing that we've talked about a lot is the importance and the necessity for technology in compliance. But budget is also really important. And one thing that goes through the minds of, I guess I'm not going to say anyone in particular, but I think a consideration out there is often, well, what would it take for us to implement policies and procedures and controls around this versus how much would we have to pay if we violated this rule, right? And what would our reputational risk be? So sometimes there's a balance. I would say that I'm more on the investment advisory, investment company act side, and that's not really the way that I think about things because there is so much reputational risk to the type of business that I'm in, and our investors are our business. But I think larger institutions like banks, there are so many people, the human capital is enormous. The people on the investment side of the business, it's so large and numerous. The assets are numerous. There's always going to be violations. So for a large banking institution, they have small violations. It's not going to ruin their reputation. But a smaller firm, an investment manager, for example, that's managing, $100, $500 million, any type of small violation like that could shut the place down because an investor sees that, they pull all their money out. So budgeting, I think, is really important. And then we've also talked about silos as part of culture and technology and separating compliance departments through the use of technology. So moving a compliance department halfway across the country because it's more cost effective, and because there is technology, they can get on web conferences and people sit in front of computers all day long. I think a strong culture of compliance you'll see out there is the compliance people sitting very close to management. So personally, I sit like 2 doors away from the head of my business, and I can't imagine either working remotely or working from home or sitting on another floor because it's where all the action happens. So any new businesses that are being launched, sometimes business people, they think of an idea and they just go with it. And having compliance and legal sitting right there reminds them, oh, what are the compliance issues that we need to be thinking about? And I get drawn into these conversations all the time. And the more I can advise and give straight answers, the more they bring me into these conversations. So just going back again to culture and what can we do as far as building our careers. think that a lot of the technology-based roles that you see out there, and some of you may have interviewed for some of these, they're a little bit more about doing the same thing every day and having an automated job, and you're the person there who's reviewing reports. Well, a lot of you are graduating from here with law degrees and are a lot better than that and may start out in a role like that, but starting out in a role like that, first, that's how you're gonna develop a foundation and build upon it. And as you get more senior in your career, you'll be able to look at reports, and you'll be able to dig and know where there's issues and know that one issue is gonna lead to 50 more issues. So if that's the type of role that you find for yourself right now and it's a difficult job market, then I suggest you take it and just build on it. And as someone else earlier on the panel mentioned, it's okay to move after a year or two because you want to expand and grow, and you put all those pieces together to get into a more broad role. I've been lucky enough that I stepped into an in-house role during the period when this industry really has changed most recently and had a very broad role, and it's only grown from there. But that's my piece of advice for a lot of you. So moving on to, that's really my view on culture and technology. And so moving on to cybersecurity. So again, I touched a little bit on training and cybersecurity, but what's difficult is that people go to work, they do their job, and aren't necessarily thinking about, this might be a cybersecurity breach, and I should escalate this to, I don't know who I should escalate this to. So again, it does go back to training. Escalation of cybersecurity issues, and this is really new for a lot of us here. I mean, just 2 days ago, the CFTC cybersecurity policies and procedures came into effect. So now we're all required to adopt what it's an information security system, an ISSP, an information security system program. And it requires identifying all different aspects of your technology and where are their weaknesses, who you have to identify a committee, who should be escalated to. And one of the things is that to the whistleblower point, I don't necessarily know that I would identify someone who's escalating a cybersecurity issue as a whistleblower, because to some of the points that were made, I think that raising an issue internally about a cybersecurity attack, it's something that isn't necessarily within the control of the business always, right? Like somebody's breaking into the firm's systems, and it's not necessarily that the firm is doing something wrong unless they're completely turning a blind eye and have no programs or procedures in place. But I choose to think about it more as a reporter. And unless you educate people, they're not able to report. So I think that's an area that it's a new area, it's being developed, and I think that training and escalation will come along with that. But just moving a little bit on to back to culture and technology. So you may have the right culture, but do you have the right technology to enhance your culture of compliance? And we've talked a lot about technology, particularly, it sounds like, within larger institutions, at banks. There's a lot of automation, but that other than on the security side, there is a lot of still manual trading and reporting, and that part of the industry really hasn't come full circle. And I think that's really it. I mean, if anyone has any questions, just more on the practical side, I'm happy to answer them.
Okay, well, we'll get to questions in one sec. I did have a comment for all of you and for Jennifer and Anik, and I think the commentators both touched upon it. So it seems to me that compliance is great value add, if you will, as a function, is that it coordinates information. So it plays a coordinating function of there are people in the firm who have information, valuable information of wrongdoing, and you want to somehow get that information to people who are motivated, empowered, and competent to act upon that information. So in the best of all worlds, your internal compliance person is able to do something about that. And what we've already seen in the first panel was that technology has an ambiguous effect on that coordinating function. In some instances, it could absolutely motivate and empower and even make someone more competent because it helps us understand things. But in other instances, it can make things even more confusing and problematic. that as the business itself becomes more and I think Christina touched on this, becomes more technologically sophisticated, that actually then bumps up against questions of competence, right? And so that when you talk about this whistleblower, you raise real questions, which is the person who is qualified to evaluate claims of insider trading and fraud may not be qualified, whether we're talking about an internal compliance person or an SEC enforcement person for that matter, to evaluate someone's complaint that, oh my gosh, my company, you won't believe this, they have 5-digit password code instead of a 6-digit password code. And I sit there and I haven't a clue what you're talking about, right? So that, I think, is a real issue about competency. And then, Onig, I think your paper raised for me a different kind of competency question, which is the people who are good at punishing and detect, right, aren't always the people who are good at prophylaxis. In other words, the art of figuring out in advance how can we structure things so that things don't blow up is not necessarily the same skill set of, oh, let's figure out who the bad guys are and, we'll sniff this all out and punish people. So both of you raise what I think are really interesting questions about competency and how we handle competency, because unless we take care of that, it seems to me the coordination function that we expect from compliance, and when I say compliance, I mean both compliance and even external enforcement, if we think about these whistleblowing programs that way, is likely to suffer. And that was sort of what I was thinking as I was listening to all of you and the concerns. With that said, we do have actually time for a few questions. So are there any questions from the audience that people have? You guys must all be, or do you have questions for each other?
Yeah, lobbied all my questions at you.
So,
Why don't I just cite a Greek philosopher, since we spent a lot of time talking about the Germans. He who knows what he knows, knows not. He who does not know what he does not know, knows not. He who knows what he does not know, knows, right? That's essentially your question, right? How do you know what you don't know? And the way to think about that is, as I was trying to suggest, develop as many competencies as you can. Work, break down the barriers between the supervisory and the compliance and the business side. Be more, to the extent that you can, given competitive considerations, communicate more, whether it's through advisory committees or industry trade groups, or sort of, even, dealing with third-party vendors to understand what other people are doing and what sort of best practices are. A lot of this the industry does, right? It's not as if the industry doesn't do it. It's just you have to say it over and over again just to remind people that, this is an ongoing challenge, and you really need to develop that kind of variety of competencies these days to stay ahead of the machines.
and I think that was Rebecca's comments about sort of on the ground, which is the competencies you had 10 years ago aren't necessarily the competencies you need today, right? So with that said, we send you all out to lunch, and we will be back here at 1:30 for the next panel. Thank you. Thank you to our panelists.